Leave that below 30.
Who did?
Mormon.
No. I've been out by 9.
You wouldn't even make it to the concert.
Well, it is officially 8 o'clock, so we will get started. So I'd like to welcome everybody here this morning. Thank y'all for getting up, and everybody's bright-eyed and bushy-tailed this morning. But we'll start with a prayer this morning. I'm going to ask Reverend Vance Smith, he'll open in prayer for us. Y'all bow with us.
Thank you, Mr. Chairman. Lord, we thank you for this wonderful day you've given us. You give us all the days, and they're all good, and you're good all the time. Thank you for blessings. Thank you for taking care of our families while we're here. Help us to do the right job and legislating for the people. But be with our families back home who are going about their schoolwork or their job, whatever they're doing, and just keep them safe. Let them know we love them. And we ask that you lead, guide, and direct us and grant us wisdom. In Jesus' name, amen.
Thank you. We're going to start with House Bill 978 today. Chairman Todd Jones, he'll come to the table and tell us about his bill.
Thank you, Mr. Chairman. Members of the committee, you should have a sub to 978 in front of you, LC 394169S. Okay, thank you very much, Mr. Chairman. Before I start going over the sub, if you don't mind, I'd like to give this committee just a couple of data points just to think about. First of all, I'd like to thank this committee. In 2021, this committee passed effectively what I call the cross the solid yellow line law. So before 2021, there was a requirement to keep a 3-foot buffer from a cyclist. However, we had not given the cars who were passing the cyclist the ability to cross the solid yellow in order to maintain the 3-foot buffer. And we were finding that several cars were having to, in a sense, break the 3-foot buffer law to maintain staying right of the solid yellow, or break the law, cross the solid yellow to keep the 3-foot buffer. This body allowed us to use effectively the same law that's used for postal trucks and then also for sanitation trucks. And if it's safe to cross the yellow line, be able to maintain the 3-foot buffer. The reason I want to mention that bill to you is 3 years later, incidents involving cyclists in the state of Georgia are down by over 25%. Now, we can't necessarily subscribe all of that reduction to that law, but we do believe it had a material effect here in Georgia in terms of keeping our cyclists safe. So I do want to thank this body for that and for pushing that bill through. The second thing I want to do is bring you now to the substitute for 978 and give you the reasoning behind before we actually drop into the language. There are approximately 10 states that have passed a similar law, effectively allowing the cyclist to use a stop sign as a yield sign. Quick data, here in Georgia, of the fatalities that involve a cyclist, about 54% are unfortunately due to, I'll say, lane usage or incorrect lane usage. 22% happen at effectively a stop light. 21% happen at a stop sign. For those of you who cycle, you know we just can't accelerate as fast as a car does coming out of a stop sign. So the idea is, with this law, can we keep the cyclist, if safe, in other words, if it is safe to use the stop sign as a yield sign, moving, especially in an uphill condition? Many of the cyclists are clipped into their pedals. For those of you who don't know, that means they're basically solidly clipped in as opposed to just with their feet on the pedals. When they have to unclip at an uphill where a stop sign exists, it creates a very dangerous situation, because not only do they now have to start, but they're starting on an uphill. And I can assure you, at 56 years old, I just don't start the way that I used to, as the other cyclists too. To give you some data, Idaho passed the law, and approximately 1 year later, they had a reduction of 14.5% of fatalities. Delaware, a similar law they passed in 2017, and 30 months later, the reduction was 23%. So I think we can see just from the data that has absolutely occurred in terms of helping our cyclists be able to go safer and, frankly, reduce the amount of frustration to the car drivers. I'm fully aware, as a cyclist myself, that car drivers get cranky with cyclists, especially cyclists who break our laws. You're only allowed to go too wide, you're supposed to stay as right as possible, etc. And some of them do impede on traffic, and I'm the first one to admit it. However, I'm also the first one to admit that there's car drivers who are texting and driving. There are car drivers who sit in the left lane. In other words, none of us are without sin. but I do want to make sure that you guys realize that as much as sometimes us cyclists do, in fact, impede traffic, we don't mean to, but those who do impede at 3 wide, or those of us who aren't staying as far right, I'd like to apologize for them, but at the same time, I hope that you see this bill as a way for us to be able to give the cyclists, and frankly, the motorists, I'll say, a little bit of peace of mind, knowing that if it's clear, they don't have to come to a full stop, but rather roll through and make that right turn or go across if it's only a 2-lane highway. Mr. Chairman, that is the effect of the bill, and any questions?
Thank you for bringing the bill and the data, and you mentioned the Delaware law, and what the language you have here mirrors the Delaware language. Is that
Mr.
you
Chairman,
understand?
that is correct. There's a little bit of modification that Jenna had to do, but effectively, our DOT, the Georgia DOT, was, I don't want to speak for them, but they favored, I'll say, the Delaware approach, and then Jenna was able to, I'll say, Georgia-ize it to be able to fit within our statutes, and I want to thank her because she did a terrific job.
Well, she always makes things better, so
Yes.
that's a good thing. We're proud to have her. Number 22, Representative Ridley.
Thank you. I just got a quick question. So when, say you're at a stoplight, and the bicycles can come, if they're in the back, they can come between the cars, correct?
A stop light, this
Yes,
is just
if you're a
in terms of
stoplight or a
sign.
stop sign, can they come between the cars to get up front to go through?
They're not supposed to go between the cars, no. Now,
Okay.
they can go to the right, but they cannot, and I know I wouldn't go between cars.
Okay, because I've seen like come up the left side, go up to the guy that's in the front, and cut to the right in front of him. And I'm thinking, if that light changes, he's going to go and not even know this guy's coming from the left side.
Correct.
Across. And so they're breaking the law there. And then bike paths. What's the rule? If there is a bike path, they must use it, or can they still run on the roads?
Yeah, so effectively, Georgia law treats bicycles as a vehicle. So we're supposed to, and a cyclist is supposed to, follow stop signs, all the limit signs. But keep in mind, according to Georgia law, bicyclists are not permitted on interstate highways. They are permitted on paved shoulders, but we're not allowed to go into multi-use paths unless the specific municipality has permitted that. For instance, in Forsyth County, where I live, they have permitted them on there. So at the end of the day, the general rule is the cyclist should stay as far right as possible. I typically stay right of that white line just for safety purposes.
Okay. All right, Mr. Chairman, proper time.
We have we have number 29, Chairman Wiedauer.
I appreciate this bill. Is it not true that if this was passed years ago, I would not have done the most embarrassing thing on a bicycle, which is to come to a stop and not be able to clip out and simply fall over?
I unfortunately have seen that happen more than once, Chairman. Yes, I've seen it several times.
Well, I will yield to Representative Ridley when he's ready.
So does that mean that you taught President Biden how to ride a bicycle too?
That was my thought, but I wasn't going to say it. But, we do have someone signed up, T.J. Kaplan. If he'll come to the, you sit at the table with Todd, you can go to the podium, whatever you'd like to do. So, just state your name and who you're with.
TJ Kaplan, I represent Georgia Bikes. I don't want to take up any of the committee's time. I just appreciate this bill, appreciate Chairman Jones bringing it and your consideration today. We very much support the measure. Thank you.
Thank you. Any further questions? I think this would be the proper time for a motion if somebody has one. We got a motion and a second. Do pass. Any further discussion? All in favor say aye. All opposed, like sign. All right, you be okay. Passed.
Thank you so much.
Thank you.
That was actually
Yeah.
funny.
And this time I want to do this bill next. Now I still this one here. So I need you to chair, but what I want to do, I want to get Miss. All right, we're going to go on to House Bill 997 at this time, and this is Driver Services Bill. I'm the primary sponsor, so I'll be turning the meeting over to the Vice Chair Barton. But to start with, I would like Ms. Shavonda Leslie, if she will come to the podium and talk about the need for the bill and why we're bringing it forward.
Working, okay. Good morning, Chairman, committee members. This is an agency bill. What this bill does is it streamlines the process to downgrade commercial CDL holders that have violated FMCSA's rule in reference to drug and alcohol usage. Currently, when someone is drug tested, a CDL holder is drug tested, that information, and they test positive or they refuse to test, that information is sent to the provider, the driver, as well as the trucking company. And what this bill seeks to do is streamline that process and include the state as well, so that we are aware that when someone tested positive and has not complied with FMCSA rules. And what that looks like is right now, when they test positive, FMCSA gives them a certain amount of time, and it's individually based, for them to have a negative drug screen and or to attend some type of program, whatever the FMCSA deems fit for them. So what may be fit for me, maybe just the negative drug screen, or to go ahead and provide a test. But the next driver, it may be that they need to do some type of drug rehab program. So this allows the driver not to employee shop, which is what we're seeing right now. If a driver tests positive and FMCSA says, okay, you can no longer drive, that what they do is they will stop working for my company, and let's say Chairman Corbett has a company, they will go to work for Chairman Corbett's company because that company does not know and their license has not been downgraded, which makes it a hazard for our highways.
Number 19.
Thank you, Mr. Chair. I guess my only question is, I guess on line 13, you say upon receipt. I mean, are you talking about receipt like, they get certified mail, they get when they test positive? I'm just trying to figure out
Sure.
how when you say receipt.
So the upon receipt on that line refers to us, DDS, receiving that information from FMCSA. What we'll do is our system will talk to FMCSA system, and it streamlines that process, and they'll push a notification to us and say this person is no longer allowed to drive because they failed to comply with our rule. The customer determines how they want that information received on FMCSA's process, FMCSA side, excuse me. They select if they want that electronically or if they want that permit mailed to them.
Thank you.
Are there any more questions? Mr. Chairman, would you like to say anything?
And thank you, Mr. Chair. And on the back end of this, they also streamline once you get the notification that they've completed get a negative drug test, or that they've completed whatever class they're required to take, then the reinstated process is streamlined as well.
Correct.
So that's on the back end of this. We stop them from jumping jobs. So if I've got CDL, and I have to take every 2 years I have to do a DOT physical, and they do all the screening, and that's where they catch these things. If your company does a random drug test, your license is suspended. Mine never have, so I'm not on wood. So. but no, this just streamlines the process. Stops somebody once they get a negative drug test, they suspend their license. They do the necessary steps to get their license reinstated, and then we streamline that process as well to where they can get them back on the road once they get that negative test.
That is correct.
Okay. Representative Ridley,
Well, at the proper time, I was going to make a motion.
are there any more questions, committee? Seeing none, it is proper time.
Make a motion to pass.
All those in favor? Light sign against. Motion passes.
Thank you.
Thank you, Mr. Chairman.
All right, well, thank you for that. The next bill was going to be 933, but I don't see Representative Mata on here yet. So we will do what? Reeves isn't here either. I know he's going to be later. Was number 19 have a,
Mr. Chair, yes, I was, after further looking in more into 933, I would like for us to table 933.
well, I'm not gonna recognize that motion at this time. I mean, we wait till we.
Okay,
adopt
I just,
the-
do appreciate it. Thank you.
So. Representative Vance, are you ready to present 447 and the changes we talked about from the last meeting? If you'll come to the.
Thank you, Mr. Chairman, fellow committee members. Operating off of LC 394161S, this substitute reflects the changes that came out of the hearing last week. One from Representative Ridley about removing all references to fees. That's been done. And delete the words public safety initiatives at the request of sheriffs. That's been done in this substitute, and I'll be rather brief with the presentation after a pretty thorough hearing last week. This bill, House Bill 447, is called the Georgia SAVE Act, Secure Automotive Vehicle Enforcement. And what it does is it will enhance compliance with uninsured vehicles and motorists and those vehicles with expired, suspended, revoked, or canceled vehicle registrations. This technology will be mounted only in well-marked patrol vehicles for those agencies who choose to get involved in this kind of enforcement. You've been given charts last week and talking points, and I'm not going to belabor those, but I would like you to look at the last page of the talking points, where 94 courts responded to a statewide survey based on 2022 figures. If y'all have got that, you'll see a little chart, Georgia vehicle insurance information, and right above that, aggregate number of misdemeanor citations handled in Georgia municipal courts. This is just municipal courts. Driving with an expired vehicle registration in 2022, there were 30,003 cases in these 94 municipal courts. Driving with suspended, revoked, or canceled registration, 6,215. Failure to maintain liability insurance, 7,923. And operating a vehicle with an altered or improperly transferred license plate was 618. That was 2 years ago. So I venture to say that those figures have increased since that time, but those are the latest figures per the survey that we sent to municipal courts in Georgia. I would ask I'll answer any questions if you have any, but I would ask your favorable consideration on this bill that would enhance compliance in a very, very necessary area in Georgia.
Number 22, Representative Ridley.
Thank you. Out of these 95 courts, well, let me go back to this. What's the percentage split on what the department gets, what the people putting the cameras in the car gets? Is it a percentage?
Sir, I don't know the answer to that.
And do you know the cost of putting these in each patrol car
My understanding is about $15,000
per car?
per car.
Okay. All right. That's all I got.
And my understanding, that's negotiated between the municipality or county and
Right. Some
the company or companies ever
some
who.
do lease purchase, some sell outright, and the split would have to be agreed upon by the company and the courts. but it stays local. It stays local.
And y'all took out the public safety initiative wordage for what reason?
Sometimes, as being a city councilman for 28 years, I know that sometimes the word initiatives has broad implications. It was determined that we really want these funds to go to law enforcement purposes. That narrows it down, that allows them to buy equipment and do things for the people on the road and in the building, not some other initiative that may take away from that.
So it would stay with the department, it wouldn't go into a general fund?
Correct.
Okay. All right, thank you.
Well,
Okay, we do have an amendment to put on this, but I believe, I was just brought to my attention, the LC number on the amendment is the old bill, not the sub, so that line is not correct. We need to,
it's really on line 55 in the version that you have now.
line 55.
55, yes, sir. Where it defines owners, it's right above. It's right above where you were, the directions you were given in the old bill.
Okay, it was three places. Let me just pause for just a moment. Okay, I think we've got it figured out. Jenna's gonna keep us straight, so thank you. But this time, I don't see any further questions. What'd be the will of the committee? Well, we got to do pass on the bill. Now we need a motion on the amendment. And Jenna, could you read the amendment for us?
Yeah.
So I don't mess it up.
So I just adjusted it so that it would look similar to how lines 47 through 49 are with the ABC.
What number?
So on line 56, you're going to insert a colon after include, and then a capital A, and then a motor vehicle, and that'll all read the same. Then line 58, you're going to insert a semicolon or, and then a capital B, and then the language that was provided, a lessor where the, and then include motor vehicle, is being operated by a lessee or another person under a lease or agreement with a lessor.
Okay, would somebody like to offer that amendment? All right, we got a motion on the amendment. Do we have a second? Okay, now we will, I think the proper is to vote on the amendment. All in favor, say aye. All opposed, like sign.
No.
Okay, the amendment passed. Now we'll vote on the bill as amended. Any further discussion? Not seeing any. All in favor, say aye. Hold on, we do have a number 18.
Thank you, Mr. Chair. I think I know the answer to this. Sorry, this is my first meeting back, but they did change it where you can't cross multiple jurisdictions and get penalized each time, right?
That is correct. Once you get the initial one, you can't be penalized in subsequent jurisdiction. That is correct. Okay, now let's vote on the bill as amended. All in favor, say aye. All opposed, like sign.
No.
Got 2 noes. The bill passed. So, and we still are missing the author of the last bill. It's going to be a hearing only. So, and we've got some time, so if we'll stand adjourned for a few minutes and give the author time to get here, hopefully. We do have the author for 933 here at this time, so we will move back to House Bill 933. Representative Montahan, I ask present your bill.
Well, thank you, Mr. Chairman. And boy, that traffic was something else this morning, so I appreciate y'all waiting on me to get this House Bill 933. Your substitute done. It's LC 394174S. So it's like to be a couple different ones. So we've got the last week we covered a bill. It was the Foundation for Moral Law, the Don't Tread on Me yellow license plate tag that we saw. And then this is another tag which is honoring the alumni of the Sanford University. With that, Mr. Chairman, I'll take questions.
And both of these are revenue sharing tags. They've both met the criteria as far as the either have pre-sold 1,000 or either have stroked a check for $25,000 to the Department of Revenue. And we have letters on both of them that they have been met all the criteria on their end as far as the rendition of the tag, 501c3. So all the requirements have been met for both of these. We do have a couple questions. Number 24, do you have your, did 24 have a question?
That was me.
Okay, I see you. All right. Number 18, Representative Kennard.
Thank you, Mr. Chair. I have some questions about the Foundation for Moral Law. Can you tell us a little bit about what they do?
Yeah, this is a group that has applied to have one of these tags. They support all sorts of different endeavors, usually surrounding teachers and coaches, teachers and others. They provide a legal resource to them, amongst others.
It's one more question, please. It's a religious group.
I think in some ways, yeah. I think they do protect the what they see as the rights of teachers and educators.
Okay. In my mind, the Revolutionary War was fought to create the separation of church and state. Do you think this infringes on that idea?
No.
Why not?
Why do I think that
Why not?
a legal group who goes and fights for the rights of teachers under the Constitution of each governing state is non-constitutional? I'm sorry.
And direct all questions to the chair instead of thank you.
Mr. Chairman, I would imagine that lawyers who are paid by this foundation, who represent teachers, represent educators, not only in the state of Georgia, but all over this United States. They work within the confines of the United States Constitution, in each specific state's Constitution as well. And I think we shouldn't try to diminish that. We have a Constitution. As people, we vote on bills here that fall within the confines of the Georgia State Constitution and the Constitution of the United States of America. And I think I apply to anybody who's willing to do the work. Thank you, Mr. Chairman.
Okay, seeing no further questions, what would be the will of the committee? This is the second hearing on this. Number 22.
Make a motion to pass.
Got a motion and a second. Any further discussion? All in favor say aye. All opposed? No. Motion carries. Bill passed. Thank you. All right, we do have one other bill, and it's going to be hearing only. Representative Reeves is here, House Bill 939. If he will come up and present the bill and tell us, what we're trying to accomplish.
Mr. Chairman and members of the committee, thanks for your patience. Had to get enough lawyers in the Judiciary Non-Civil Committee to give them a quorum. I was here early this morning like y'all were, so appreciate your patience. House Bill 939 is the Breaking the Cycle DUI and Reckless Driving Education Act. This bill requires those charged with a DUI that's resulted in a suspension of their driver's license to take a risk reduction course before applying for reinstatement of a provisional license. This bill won't cost the state $1, and what it does is it intervenes and it encourages folks who've had a DUI, points accumulation above the certain level to get their license revoked, super speeders or drag racers to complete a DUI and reckless driving risk reduction course to apply for reinstatement of their driver's license. As a lawyer in Gwinnett with a ton of traffic issues out there, I don't do DUIs, by the way. Only 2% of those charged with DUI go to trial. Those cases are resolved through pleas and other adjudications. So a vast majority of these serious offenses are pled down, and folks don't receive the reduction course in a timely manner, and that's a vital tool for training and education. We have here this morning Ms. Ina Mitchell from who does driver's education and reducing recidivism. It is key to have the course in close proximity to the offense. That maximizes the reduction in recidivism. That's what this bill will do. The substance of the bill is in Section 3 of the bill, and by the way, this bill has been revised since it was filed. We're working off LC 394130S. Section 3 has the substance of the bill. We did remove child support. The original draft of the bill had a reference to child support, but this bill in lines 90 through 92 removes, or 91 and 92, removes child support. So it focuses on these driving offenses of DUI, points accumulation, drag racing, and super speeder. Sections 1, 2, and 4 refer to the proper credit for DUI risk reduction on the front end of the sentence and ensure that the course will not have to be taken twice by the offender. And those who are charged with DUI that results in a suspended license will only have to be credited with the DUI risk reduction if they choose to have their license reinstated before the adjudication of the DUI. All other offenses will have been adjudicated and sentenced. The DUI risk reduction course will have to be taken on the front end before reinstatement of the driver's license. You may have read in the news there was a tragedy in Gwinnett County. A state trooper died in an accident last week, and there was a motorcyclist going 140 miles an hour. And I will be asking for that motorcyclist driving history, but it's situations like that that put the public at risk, the driver at risk, but most importantly, law enforcement at risk if you have people who are out there with serious offenses without having intervention and education at the driver's expense to where they have to take responsibility for getting their driving habit straightened out. And this bill will do it. This will make the streets and highways safer in Georgia for the sake of families of Georgia and for our law enforcement. So I yield for questions and also have Ms. Ina Mitchell here who can talk about that program that has worked with military personnel as well as other drivers around the country in reducing recidivism. Thank you, Mr. Chair.
Sorry, we have several questions. Number 22, Representative Ridley.
Thank you. I do got a few questions. So you have to take this class before you actually go to court, correct?
Yes.
So are we not violating amendments here by having to do this before you go to court and even convicted?
Representative Ridley, no, because there are numerous driver's license issues with driving where, having a driver's license, it's a privilege in Georgia. And so if someone has had an encounter with law enforcement related to DUI, driving 140 miles an hour, accumulating points through multiple offenses, asking them to go take a course, and this isn't a criminal sentence, this is just saying you need to go get some remedial education on driving safety and break that cycle of dangerous driving habits. So it's not a criminal penalty, it is an educational matter.
But you're requiring them to do it?
Yes. Yes.
And what's the cost of the class?
It varies, but it's less than $500, I believe.
Oh, I was saying 600 is what I was saying. But you can't do it online class, you have to do it in person?
I believe there are a variety of courses that are available, and in the bill, I would defer to the committee on what's on paper on there.
Chairman, a couple.
I know there are both online and in person are available.
All right, let's go to the super speeders. What's the super speeder? Is it 15 over? Is a super speeder?
I believe it's the level. Like if you're in a 35 mile an hour, it might have to be above a certain level, more than 15.
Is it 24? All right, and then where does, like, you're talking about like the guy going 140? I mean, does that not constitute as like reckless driving at that point, or?
Absolutely. Yeah, they would fall under multiple of these offenses.
Okay.
And I would imagine when all is said and done, there's a likelihood he might have been under the influence of something also.
Well, and I guess my problem with this bill is this: we've got a problem with DUIs here. We've had the prosecutor council come because the Supreme Court's made some judgments on doing your test out there in front and refusing to do it or whatever. And then, like you said, most of them's pled down. Most of them's thrown out because of something that's happened, and requiring somebody to go have to take a $600 class before they even go to court. I don't see how that's even anywhere near being constitutional, because you're forcing them to do it. I mean, you're saying you got to do this before you even go to court, and that's my biggest burr in my saddle on this thing.
And I share your concerns about the Constitution, and I sat in hearings last year about what to do in light of court decisions. I think this is something that no matter what the law ends up being on DUI in Georgia, if you have somebody who's super speeding, DUI, if they've had multiple offenses to where they've reached the number of points to get their license revoked, if they're out there drag racing, they ought to have the mirror held up to them and say, you've got a problem with your driving habits, and you need to sit down and spend a few hours getting some education, some remedial education to break that cycle and to change your behavior, because you're not only endangering yourself, You're endangering other people on the road, and as we've seen last week, law enforcement. So,
So-
it's less of a legal question as it is an educational question about driver safety. We've got 5 million people in Atlanta, 11 million in Georgia. This will make drivers take responsibility to be safer.
So is you saying this, you don't have to do this after multiple?
That's on the points accumulation. So if you've had, 3 acts or 3, incidents to where you've accumulated a number of points to get your license revoked, this would kick in.
Okay,
As
so
well
it would
as
be the
super
first
speeder.
time you get a DUI, first time you get a super speeder, you wouldn't have to.
No. Super speeder, this would apply. DUI, it would apply. Also, points accumulation, it would apply.
And
drag
right
racing.
now, if you are convicted of DUI, are you not required to take a DUI class after a conviction right now?
If you're convicted, correct.
But you're not. We're going to make you do it before you're even convicted.
For the 98% of DUI arrests who don't get convicted, this would apply. And also, of those 100% of DUIs, a lot of those are repeat ones. So reducing recidivism, that's what this bill is about. How do you break the cycle and change risky behaviors? Because it gets worse and worse. A person on their 3rd DUI is probably in worse shape than they were on their first. That motorcyclist driving 140 miles an hour, he's probably driving worse now than he was a year or 2 ago. This breaks that cycle. This sits somebody down on their own dime and says, you've had a serious problem on the road. You need to change your ways.
All right, we have several more questions. Chairman Prince.
Thank you, Mr. Chairman. Thank you for the bill. 2 things, and I think to Representative Ridley, I may be answering this correctly or not, but right now, you're not required to go until you go to court. However, if you go, and I'm talking risk reduction, I'm not talking DUI, if you go before you go to court, the judge sort of says, okay, this person has been proactive, they know they made a mistake, and they basically admitting to it, and they get in the training. So most of the time, the judge is a lot lenient. So from my experience, that's usually when they go. Not because they're required, but they just want to get the jump on that. But my question to the author here is, you're saying DUI or risk reduction program. So they have a choice? And the reason I ask that is because they're two separate courses. One costs a lot in the DUI piece, and it's more intense than the 6-hour that I know of risk reductions. Is there a difference?
I believe they are similar for these serious offenses of super speeder and drag racing with DUI. They have both in there, I believe. And also, Chairman Prince, your point about the timing of it, what this bill does is it puts the course closer to the offense. If somebody right now, they can have 6 months, a year between when they got arrested and when they take the course, but the military and other folks who are successful in reducing recidivism in large numbers, you got to have that course close to when you had that encounter with law enforcement. That's when people change their ways the most, when it's fresh in their mind and when they get the tools to change their ways.
Chairman Powell.
Thank you, Mr. Chairman. Is it not true that what this bill is doing is just codifying what is a common practice with the courts and offenders right now?
Chairman Powell, it will codify and it will increase and spread a successful model.
Right now, I think a lot of the judges, as my good friend said a while ago, a lot of the judges will show a little bit more leniency. But in this particular case, by codifying it, it just basically says this is what you will do, and not leave it up to the judge and the offender.
You've got 500 cities in Georgia, 159 counties, and this increases the bar statewide and something that puts lives in danger right now.
Number 19, Representative McLean.
Thank you, Mr. Chairman. I guess, as I look at it, you want this bill, it was brought by, was it brought by the DUI schools or the drug schools? It's $600. I mean, it seems like a lot of money to spend. So I'm just trying to figure out what caused you to do this. Was,
Sure.
the DUI schools come to you, or any of the vendors? Or?
Miss Mitchell is close by Gwinnett, and she could speak to that, and she can talk about the reducing recidivism. A1 driving school, which is in Gwinnett, they can talk a lot about it, but $600 versus a fatality versus paralysis versus brain damage, it's a small price to pay. And the person.
So why don't we just make it 1,000 or 10,000?
Well, I think
I mean,
the
that would
market-
still be a small price to pay.
Well, I think the market takes care of that. I think if you have more people taking it and more people giving it, you know, the prices may come down. Also, online technology and things like that over time can make the price go down. But again, we've got the status quo. How do you change the status quo? This is a way to change the status quo in favor of safety and breaking the cycle.
Thank you, Mr. Chairman.
Representative Alexander, Bill 15.
Thank you, Mr. Chairman. So we're talking about 98% of the people this would be affected by this, and you're saying $600? Why not two? Why not one? Why not three?
I didn't say $600.
Okay. How much is the cost then?
This doesn't set the cost.
Okay.
So, someone's seen it priced at $600. It varies.
Right.
And you know, with having a statewide bill rather than, you know, a patchwork, I would imagine more people are going to be offering it and more people are going to be taking it, and that should decrease the cost.
Right. So right now you don't know the cost?
I think it varies. I think 600, 500, somewhere in that range.
Okay. Thank you.
Representative Ridley, number 22.
Let's go back to something you keep bringing up. Like, if we do this, this is going to stop it. But we're already requiring to do it after conviction, and it's not stopping it. So we're going to do it before conviction. And you keep where's the data at where other places have done this before, and it showed a difference in them doing it before and after.
I think now would be a good time to hear from Ms. Mitchell. If I could
Yeah.
yield with
That'd be that. And then I guess right now, if I'm a judge and somebody does something on their own, I kind of take more leniency on that person because he's got motivated to do it than just requiring somebody to do it. Is the reason I think judges probably look at it a little bit. Now, if you just say, "Hey, you got to do it," you know, everybody else has got to too. So how's that going to help a judge
Again, it's
decide?
the timing of it. If you do it on the 2% of convictions, that's going to be months or years later. If I could yield to Miss Ina Mitchell, who's on the front lines on that.
If she just state her name and who she's with.
Absolutely.
Okay, thank you. I'm Ina Mitchell with Prevention Research Institute. So one clarification, the cost is set by the Department of Driver Services, and it's $360, and that's for the entire assessment and the course. So first thing I'd like to mention is that Emory University did a recidivism study here in Georgia back in the late 90s. And it was a really interesting study because at that time, not everyone was required to go through the program. Those who were less severe could actually assess out. So they would take an assessment, depending on how the results were. Some went to the program, some did not. So think about that for a second. Your least severe were not going through, and they recidivated at twice the rate of the most severe. All right, so that's a huge lesson there, that just because I am least severe, we would think that person would not have as many problems, right? And yet, without the intervention, we were seeing greater recidivism at twice the rate. There's been other recidivism studies since. It's pretty clear the program works. There's a study that was done on just diversion programs in general, and this one looked at 47 studies. When we have the intervention close to the time of arrest, we see less recidivism. It's just clear in the data. For me, the thing that I'd like for you to think about is this is all about risk perception. If I perceive risk for something, I'm less likely to do it. So if I perceive risk for speeding, I'm not going to speed. And it's kind of interesting. If we all think about how we perceive risk for driving fast, we typically, not always, but typically perceive it's more risky for other people than it is for ourselves. And that's the difference between what we call general risk perception and personal. Same thing happens with impaired driving. There are very few people that get in a car and drive impaired because they think they're impaired. When I get in a car, and if I've chosen to drive impaired, it's not because I think I am. I feel okay. It's a high tolerance issue. Someone who has a glass of wine and feels impaired, they don't get in the car. They don't do it. And people that have a high tolerance, they feel fine after they've been drinking. They do not have any reason to think that they shouldn't get in the car. And until I understand that difference between what I feel and what's actually happening, I'm going to keep doing it. Because there's no reason for me to think that I'm going to create that kind of tragedy. I feel fine. And that's the kind of thing they're learning in the risk reduction program to help reduce risk, to help me not put myself or others in that position. And that's why having it closer to the time could potentially reduce a lot of problems.
Tell them about the military, how they've used this.
So the program is used in all branches of the military. It's used in the Army, the Marines, the Navy, and Coast Guard, enterprise-wide, worldwide. Air Force, a little less utilization at this point. It's also used in the National Guard, Customs and Border Protection, and again, after someone's had a policy violation, they get the program pretty quickly. The Marines, it's actually had such an impact that they're now using it in prevention as well. So new Marines that come in also get it, even without a policy violation. And they've been using it for probably 15 years at this point.
Okay, we do have a question. Chairman Powell.
I have a question, just got a statement. The lady was not correct when she said that those $360 fees are set by DDS. They're set by statute.
Statute, yes. Thank you.
And the reason for the statute is because years ago when we started the DUI programs and such as that was to be sure that all of them were on a level playing field instead of some of these schools being able to offer discounted services. We were always concerned that discounted services and all would create basically a lesser course because they're all given the same basic course to teach.
On that point, is that in-person class or is this online? They just 360, whether it's online or in person. Is there a difference in that?
The cost is the same. Traditionally, it's only been in person. With COVID, there was an emergency change, and some did virtual, and they have continued to do that up to this point.
Okay. Any further questions? Pretty good. We got 7 minutes left. Like I said, this was a hearing only. We have one. Chairman Powell.
Did you say a hearing only?
Yes. Today all right. Any further comments or questions for the author? Thank you. We'll see everybody next Tuesday at 8 o'clock. Thank you. Before everybody leaves, I do have one change I need to. You're good. Back on 933, DOR did have a request that the implementation, the date, effective date be January 1, 2025. That's not on that.
January 1, 2025.
Okay, it's on there. Okay.
Yeah, it's on there.
Just want to make sure. No change. We're good. Thank you.